Good afternoon, everyone, and welcome. We have a really exciting webinar today, a discussion with a excellent panel of experts to talk about worldwide privacy law. What is new? What is this year going to hold for developments for worldwide privacy law? There's a lot going on. And with me today, I have three great experts on this subject. Lavonne Burke Hopkins at Dell, who has spoken about these issues many times at my events and really has a wide-ranging knowledge of the world on and developments on privacy. Rob Corbet at Arthur Cox, who also has spoken at quite a number of events that I've organized and I've been to, who knows EU privacy and GDPR inside out. So really excited to hear what you've got to say. And finally, Gabriela Zanfir-Fortuna from FPF, who is been focusing on worldwide privacy developments for many, many years and writing really wonderful things at FPF on the blog and various reports, and has been speaking at a number of events too, and is really a go-to expert on the globe. So thank you all for joining me today. So I'd like to start by talking about the regions of the world, the countries where new developments are going on. New developments have happened over the past 5-6 months, and what we see that's likely to happen this year, countries that are on the cusp of passing new laws, kind of a sense of what's happening. And then after that, I'd like to talk about some of the broader issues, the cross-country issues like data localization, cross-border data transfer, enforcement, and things like that. So let's begin with a kind of a world tour. What are some of the new developments that have recently happened that you find most notable for privacy worldwide? And I guess why don't I start with you, Lavonne?
Sure. So Dell, as many people know, is a very large multinational organization, and so we do operate in a wide variety of countries around the world, and so we are always monitoring both privacy and security related laws that are emerging in all these jurisdictions. So right now, I think where I'm spending quite a bit of time is in China, in particular, with the emergence of a suite of laws, both in the privacy space as well as the security space, data security space, with PIPL, as well as the data security law, and some of the new rules that are coming out about cross-border data transfer and app development, etc. And so that's a key hotspot for us where we're spending a lot of time. I think also in part because the laws and the definitions are still evolving, which make evaluation and assessment a bit more challenging than some that are fully developed. Another area I would say too that we're watching pretty closely are some developments in Brazil around the new security measures that are going to be imparted for protection of personal information. And then maybe one other, and I won't take everyone's thunder for all the other laws, but another country that we're looking at really closely now is Australia, with some of the new security related laws that are coming out there.
And so on just a quick follow-ups on Australia, is this all on the security side, or is there anything going on with their privacy law, which is quite old?
It's more on the security side. However, it's broad and it's still under development, and so we expect that some of these additional controls are going to, we already know that they're aimed at security of data in general, not specifically with personal information or personal data, but it's not too far of a stretch that whatever security requirements are going to be levied from just general data and broader scopes of data are also probably going to find their way into the personal information realm. And so for us, we like to kind of take the high watermark there and try to make sure that we're protecting all of our data at the same levels to the extent that we can. And so we're monitoring very closely to really see how that emerges and if there is any additional crossover.
Another quick follow-up too. You mentioned Brazil. I'm curious what's going on there more specifically.
Yeah, no, so we've seen some guidance that has come out recently about additional, basically technical and organizational measures, if you want to think of an analogy, that are going to be required for protecting personal data. Still seems to be in its infancy with respect to what the actual meat and potatoes of that is going to include, other than just saying, appropriate security controls and measures have to be in place to be able to protect personal information. But we don't know what those mean. And so it can be interpreted in a lot of different ways. And similar to, when GDPR first came out and we had the requirements to protect personal information, there wasn't a lot of meat on the bones to understand what those minimum requirements were going to be specifically from a security perspective. And so we're kind of in the same situation with Brazil now, waiting with bated breath to figure out what exactly those nuanced requirements are going to entail. And so those are areas where, we're really looking for opportunities to be able to get involved early in the, rulemaking process and whatnot, to be able to help potentially shape some of what that legislation is going to look like when it's in its final form.
Great. Thank you so much. Rob, what is going on in the EU? And if you certainly feel free to talk about it anywhere else too.
Yeah, what's going on in the EU? You could write a book on that, couldn't you? You add that to your to your list of academic accreditations. I guess the biggest challenge in the EU at the moment is there's two aspects to it. The GDPR is maturing to the point that we're now starting to see, enforcement and trends and divergence of approaches and so forth 4 years into the GDPR regime, and that's certainly presenting a lot of challenges for companies trying to operationalize the GDPR across the EU. The other thing I think that's causing people a lot of concern is the tsunami of additional legislation that's coming down the line. So the European Digital Services Package is looking at a whole lot of other areas that may not be just privacy specific, but impact upon privacy and security in a major way. So things like the Digital Services Act, the Digital Markets Act, the AI Act, all at different stages of their evolution, and all of them having, as yet unknown consequences for privacy professionals, I guess, because they will put a lot of pressure on governance structures within companies and so forth, who are currently probably struggling even to grapple with the day-to-day challenges of working under GDPR. So I'd say it's the difficulty of keeping up with the expectations of regulators as they become clearer under GDPR, and then the separate, forthcoming pressures that will come from the emerging legislation.
Gabriela, what areas do you have your eye on in the world for privacy law developments?
Well, everywhere. But please allow me first to acknowledge the very stressful, dire situation in which some fellow Europeans are right now, experiencing literal war. And I want to take this opportunity to express my solidarity with Ukraine and the people there, and just to let everyone know that we understand in the bigger picture of where things are. It perhaps sounds strange talking about privacy law and developments, but I don't think it is strange. Because ultimately we all hopefully strive to live in a world where fundamental rights are important and protected. So acknowledging the situation that Europeans at least are in right now, let me point out some of the developments that I'm monitoring and looking at with a lot of interest in the beginning of this year in terms of developments in privacy law. Speaking of fundamental rights, and because Lavonne mentioned Brazil, I think it deserves also a mention, the fact that Brazil decided to include the right to data protection as a constitutional right, separate to the right to respect for private life, and that happened very recently. It was adopted by the parliament in November, I believe, of last year. And then there were several procedural steps before everything became official quite recently. And I think that is a very interesting development, having the same type of recognition of data protection that we are seeing in the European Union as well as a distinct fundamental right than the right to respect for private life. Elsewhere, where we are seeing interesting developments, I would say India is one of the very, very big developments that we've been following. A bill for personal data protection, the Personal Data Protection Act, was introduced in 2019 in India. There was a very long process in the Joint Parliamentary Committee debating the proposal and coming up with amendments. The report of the Joint Parliamentary Committee was published at the end of last year or beginning of this year, in any case, very, very recently. And we are currently following the process there. Some developments after the JPC report was, in fact, were very interesting in the past couple of weeks, because we've seen media reports in India saying that it is a possibility that the entire process will be restarted. So that was quite interesting to see. The government considering technically the possibility of starting and rethinking the entire omnibus bill. But other than media reports, we have not seen that. So in India, things are still a bit up in the air. We have seen some progress, but at the same time, the reports that everything can be restarted from the very beginning are a bit worrying, I would say.
Before you go on, I'm just curious on India. What do you think the holdup is? Because there's been this pressure to have a bill ever since the Supreme Court case, and that was many, many years ago, even before 2019. And they've been working on this, and they finally come up with something in 2019, and everyone said that's the year. And then everyone said 2020 is the year, 2021 is the year. Now we're in 2022. And so to hear we're going to restart it, possibly. I just, what is the, I don't quite understand what the controversy is, or what the holdup is. Like, why is this so difficult? Is there a political, hot potato issue that they're dealing with?
There are a couple of elements that trigger attention immediately, particularly after the report was published. And one of them is the fact that the Personal Data Protection Act became the Data Protection Act. So the word personal disappeared from the title, and this is because the intention is for this bill to cover both personal and non-personal data. And this would be the first time when we are seeing both personal and non-personal data covered by a general data protection law that is built on the same core pillars as the GDPR was built on. And well, there are some distinctions to make there, because not all of the obligations clearly will apply to non-personal data, just some of them. But in any case, this is one of those very important shifts that came with the JPC report. Another element of discussion is around data localization, and I know we will continue to talk about that further on. A key topic debated in India is also the extent of the exemptions proposed for the government processing personal data. And we know that there are a lot of opinions there, and some propose very, very broad exceptions for government bodies, where some voices argue that the exceptions are too broad. So these are some of the elements that make the process quite difficult. At the same time, a lot of the holdup has been as a consequence of the pandemic, and of course, other priorities taking over as the top list of interest for the parliament there. I would also want to briefly point out some developments in Asia. In fact, I think this year, some of the most interesting developments and some most accelerated ones are actually happening in Asia. So we already talked about India. Lavonne mentioned China and how much is happening there. And we are indeed sometimes at a loss of words just seeing how many guidelines and regulations appear. And there are also regional level, municipal level data protection guidelines that appear, and it's quite difficult to even keep track of them. More than that, Vietnam is currently quite advanced in debating their data protection decree. Australia, on top of the data security developments that Lavonne already mentioned, they are in the middle of revamping the Privacy Act in Australia, and apparently the intention is to have a very significant comprehensive overhaul of the Privacy Act. So a lot of attention is spent in that direction as well, with already a second round of public consultations on specific questions that just took place. There are also very recently, we've seen amendments to the Singaporean law, and now there is this new Singaporean Data Protection Act that is being applied for only about a year now. And companies are getting used to being able, for example, to rely on legitimate interests as well as an exemption on using consent as a lawful ground for processing. The amendments of the Japanese data protection law will become applicable 1st of April, so very soon. That's also something that we're following. Sri Lanka has a bill. So honestly, it's just there are a lot of things happening in Asia Pacific, not just Asia. I have to mention two other things before finalizing the tour of the world. We're also keeping an eye on Africa because there are laws that just either very recently entered into force, like in South Africa, POPIA entirely entered into force in the past year. There are bills being discussed, like in Nigeria, which already has a regulation, but the parliament, as I understand, intends to adopt an actual law. And we are seeing some very significant application of data protection law in Kenya, where one of the superior courts very recently, at the end of last year, invalidated as having some unconstitutional elements the law proposing a digital ID, and relied on the data protection law that had just become applicable in Kenya very recently. So lots of interesting developments in Africa. And then I would not want to finalize this without looking at North America. We're seeing, of course, state legislation in the US that's subject to a lot of activity. Even today, I saw news that Utah apparently is our newest state in the US that will have a data protection law. And then, of course, Canada, which intends to adopt a federal privacy law. One was already proposed last year, in the past year, and something it was withdrawn, but we are hearing about intentions to introduce it again. And then Quebec, the province of Quebec adopted a very GDPR-like law quite recently, in the last year in any case. So a lot going on.
Yeah, wow. There's so much happening. There's a few things I also have noted too that we have. I believe Zambia has recently passed a law just last year. There's also, I believe, Mongolia had a bill that I think finally passed. Although I just read it in one article that I think it's passed now. So they have a law. Jamaica has a privacy law that's very similar to the GDPR. Has a lot of the parts of the GDPR, and we're really seeing, especially in the Latin American region, a lot of activity with a number of countries in the last few years having passed privacy laws. So really, all around the world, we're seeing tremendous development happening, and it's really interesting to see where it's going, which is soon. Most of the world's going to have a comprehensive privacy law. Pretty much everyone except the U.S. I'd like to. Does anyone have anything else on the world tour before I jump into the more broader issues?
I should probably mention the UK actually, because the fact that we've now almost forgotten. COVID was good for one thing; it got us to forget about Brexit for a while. So if you lived in this part of the world, we talked a lot about Brexit for a long period of time. It has come along now, and it's a reality. So now I think a lot of my clients would certainly have to think separately about the UK in a way that they haven't had to think about the UK before. And at the moment, the laws of the UK and the EU are very closely aligned. But as time moves on, I think the intention of Brexit was that those laws would stop aligning. And I'm sure we'll talk about adequacy and transfers and all of that if we have time later on. But I certainly think it is a feature now of what's the UK going to do next, having adopted Brexit.
What do you think? What direction do you think they might go in? Because I think the initial one was like, let's just take the GDPR, change a few words in it, and put it out there and get adequacy. But now I hear there's new desire to change it. But I guess what direction are they want to change it in? Like why where do they want to take it? In what ways?
I mean, the public appeal. The populist approach is it's to get rid of the red tape, cut through, make it more business friendly, et cetera, and that's consistent with the broader Brexit, populism, I suppose, that led to Brexit in the first place. Of course, implementing that's a lot trickier than it might look, because had they jumped off the deep end and done some of the things that the UK politicians said they were going to do in the lead up to Brexit, they wouldn't have got their adequacy decision. So now they have an adequacy decision that will last up to 5 years, but could be pulled from them at any time. They've got a very interesting scenario now with their ICO now having to give opinions independently of any EDBB influence. So, is that an opportunity for the UK to adopt different types of interpretations to some of the standards we're seeing in the EU? And or is there an opportunity for the UK to even change their laws in dropping some of the areas that they regard as business unfriendly? So there has been some discussion papers and so forth published in the UK looking at sort of getting rid of the red tape, but it's very hard to see how any meaningful divergence wouldn't jeopardize their adequacy position. The other thing to note as well is they've adopted their own SCCs for UK transfers as well in very recent weeks. So again, even that introduces its own challenges, I suppose.
Yeah, I'd like to get into cross-border data transfer as a broad issue, and this certainly has been a really challenging and difficult issue, especially after Schrems 2, and then recent enforcement decisions that are really showing that transfer is hard. And I wonder, when I look at the adequacy decisions, it's hard to find a kind of principled, consistent thing you can abstract from that, because they've said that a number of laws are adequate that I think are very dubious for adequacy in certain ways. I mean, and you look at different, Japan has a lot of notice and choice in its law. That's okay. The UK and Israel are surveillance societies, and I guess that's okay. And the you look at New Zealand's law, and it's incredibly weak with very small penalties. Same with Argentina, and those are okay. And I look across and I think, like, well, is there any principle that really matters? Because when I look at different laws, a lot of them are missing key components of GDPR. So it seems like you can just take away almost every piece of the GDPR and you're could be adequate. And I guess then it's a question of, do you have is it just how many? You have 2 out of 10 or 5 out of 10? And then there's the whole other piece, which is, even if you're perfect, but you have a lot of surveillance, is that going to ding you? And I guess the UK experiment was, let's just really test that out. We will do the GDPR verbatim, and then we'll really see, and but I just wonder, what's going on, and is this just politics? And because one take is, they gave adequacy early on to Canada, and they gave it to Argentina and Uruguay just because, hey, we want to recognize someone in Latin America, and they were early movers, so let's reward them. Let's reward Canada for being an early mover. But I just wonder, would adequacy be given now to pip it? I struggle to, and a lot just might be just more, rewarding countries for moving early rather than actually having real substance. And it's not clear what adequacy means anymore. So I don't know if there's really a clear sense of adequacy, or if it just is whatever, because I don't get it at this point.
I might jump in there. I mean, I don't get it either. I never did get it, really. For 20 years, it's we've tried to paper up some sort of international transfer mechanism, whether through safe harbor, privacy shields, standard contractual clauses, and adequacy decisions. And if you try to find a thread, that holds them together, it's not a very strong one. I think what shines the light on it now are the ECJ decisions, that effectively say, hang on a second, I don't care what basis you're leaning on to transfer your data to that other jurisdiction. Does that jurisdiction offer an essentially equivalent level of protection, right? And you would have thought that companies would be able to rely on arrangements that had been signed off between blocks, like, safe harbor and privacy shield. If two, superpowers can come together and agree that as a mechanism to transfer data, surely companies could rely on that. Well, it turns out no. Similarly with SCCs, which are an organ of the European Commission, again approved as a sort of a mechanism to ensure essentially equivalent levels of protection through a contract. Again, as we've seen now with Schrems 2, now that doesn't work either. Every transfer has to be assessed on a case-by-case basis with a transfer impact assessment and so forth. So the reality is, exactly as you described it, is that there is an expectation on companies that there is some common thread that should be holding all this together. But instead, I think everything is just sunk down to the individual controller responsibility level. in the absence of any political consensus or any even common thread of a baseline thread of data privacy standards that you would have expected. So a lot of the talk then moves to a sort of an OECD style global playbook for privacy that people would sign up to. But I think we must be a long way off of that. I'd be interested in others' thoughts.
Yeah. Well, even doing the transfer impact assessments, I wonder what do you focus on? Are you supposed to do, you can analyze the law, and how do you do that? Sometimes it's easy if there's a comprehensive law, but imagine the U.S. I mean, you write a treatise, and then there's the other issue of what is the state of government surveillance, which is, I think that's hard even for experts to figure out for various countries, because a lot of what goes on is not publicly known, and might diverge very differently from the law on the books. So I don't know how we're expecting companies to make sense of that, and if this documents really have meaning, or what it means to do one of these beyond just. I really don't know, because to me it seems like a almost very difficult, impossible exercise to sort of draw all these up for every transfer in every country.
Yeah, and maybe just before my final point on this would be the Google Analytics decision recently is a classic example. I mean, the Austrian regulator determines that Google Analytics introduces harms, arising from the transfer of the data. And Google come out and say, you know what, there's never been a governmental request for Google Analytics data. So on what basis has harm been identified here, if that is what people are trying to protect against? But I don't want to hog the floor.
If I can to briefly offer my perspective here first, Dan, to your question on what's happening with adequacy, right? I mean, why does Israel and have one still, New Zealand and so on? And then we're seeing what's happening with the US and the Privacy Shield. Well, I would say one thing that is happening, exactly as Rob pointed out, is that the Court of Justice of the European Union only got to say something about the US adequacy. Because if you ask the European Commission, in fact, decided that the safe harbor was adequate. And then it decided that Privacy Shield was adequate. And the European Commission, from its perspective, as the executive branch of the European Union, thought that all of these laws and jurisdictions, in fact, are adequate. I would also point out here that I don't think any of the pre-GDPR adequacies were updated after the GDPR became applicable in 2018. So that's like the adequacy for Israel, the adequacy for New Zealand are still not officially updated with the new criteria established by the GDPR in Chapter 5 in much more detail than what was available under Directive 95. But the confusion, I think, comes from the fact that we might tend to think of the Commission and the Court of Justice with this as being the EU, but they're not. We are talking about completely different things. And for our American audience, think about it this way: the Court of Justice is the Supreme Court, right, in the EU, and it can sanction whether laws adopted are constitutional, unconstitutional, or anything like that. So I think this is where the frustration might come. I'm not sure how the Court of Justice will, if they get to judge any of the other adequacies, what will they say? We do have some indication for the UK because we had the case Privacy International at the end of last year, and the court had some things to say there as well. In that particular case, it had to look at the laws governing collection of data in the national security space in the UK, but not in the context of adequacy. So I just wanted to throw that perspective in as well.
So when there's, I mean, it does seem like there's this very big difference between the Commission and the ECJ. The ECJ, it seems much more idealistic. They are, I think a little less practical. They kind of hold it as, I think, following the principles. But the Commission seems much more pragmatic. I mean, basically, Shield, and before it, the Safe Harbor, were basically, warmed over versions of, pretty much what the US already does, with a couple extra small goodies. But it really is not that radically different. And so that was adequate. And you look at the adequacy decisions, it paints a very different picture. It paints one that's almost like just a kind of nod and without a lot of principle behind it, just for various expedient and pragmatic reasons, recognizing some countries as adequate. So it's much more practical and political, whereas the ECJ seems to be a radically idealistic approach, and it keeps having this clash, right? They strike down Safe Harbor, and they put in Privacy Shield, which is Safe Harbor, like one click warmer. And that's struck down. And so I just wonder is this gonna keep happening, this battle, or at some point, who's gonna win, and where's this gonna go? Because it definitely, I see this big tension here, and I think they don't see eye to eye. Like
I think it will continue to happen, and the key here is fundamental rights again. So I'm going back to the key, yes. So fundamental rights, because we have the charter, the EU Charter of Fundamental Rights, that the court has started to directly apply in 2009. So quite recently, right? And we do have the right to personal data protection provided as a fundamental right in that charter. So think about it this way: how here in the US, the First Amendment, the Second Amendment, they are sacred, right? Very difficult to touch them. The Court of Justice of the EU is building something like that for a set of rights that has been provided for in this charter adopted in 2000, but then that became applicable together, once the Treaty of Lisbon became applicable in 2009 as well. And this is the reason why the court is taking such idealistic and principle-based approaches, and that are quite unseen. They're really not common elsewhere. And this is why I think developments like the ones I'm seeing in Brazil, when I told you that at the very beginning, I think that's very significant, that now the Brazilian constitution has this right to personal data protection provided separately. This will be very consequential on the medium to long term, right? We won't see it now in compliance programs, projects, or so on, but we will see how consequential it will be further down the road. So because of the charter and how the CJEU interprets and applies it, and because of this particular Article 8 of the charter, which you will see that played a crucial role both in Schrems 1 and Schrems 2, this is why we have this split, right? And the European Commission is indeed very pragmatic, and it's supposed to be very pragmatic. That's the role it plays. But then, since the EU is a rule of law, right? They're like you have the same checks and balances that you have here in the US, and we'll have to get used to that if we are considering the EU as its own legal order, which I believe it is.
Lavonne, do you have any thoughts on cross-border data transfer?
Yeah, and I apologize, I've got some external background noise. It just started, so I've been staying on mute. But I will tell you that it's an increasingly difficult situation for multinational companies. to try to be able to abide by, potential regulations, consent requirements, et cetera, for each of these jurisdictions and handle them very differently. We're seeing very restrictive regulations potentially coming out of China, as I mentioned earlier, and really trying to understand how not only just for personal data, but for other types of data, core data, critical data, general data, that these same type of restrictions are also going to be likely put in place and are really going to inhibit trade and the ability to freely do business in those markets. And so while it's a balance, I think, of these governmental entities trying to protect their national rights and the rights of their citizens and whatnot, on the flip side of that, it also potentially is going to restrict the ability for multinational companies to provide services in those areas, as well as really, provide the best level of protection that they can if they're having to make nuanced changes for every single jurisdiction, which is not feasible. And it, as it's great, we have this, everyone has a comprehensive privacy law, or effectively will, but compliance with all of those that are disparate requirements across the board makes it extremely challenging. And unless there's some harmonization, I think organizations and companies are going to have very difficult choices to face, as they have budgets that they have to operate on, and unfortunately, data protection is not always the top capital allocation of across their organization. And so while it is definitely a top priority of a lot of organizations, such as it is with Dell, you still have to be able to sell products. You still have to be able to sell services and provide those services to the constituents of the countries there. And so it's a balancing act, which is very, very difficult to manage. And as we see this ongoing, to your point, striking down of the provisions and safe harbors, et cetera, that allow for companies to easily or more easily do business, I think you're going to start seeing some pushback and really some advocacy to get to some level of harmonization and standardization that's acceptable.
Yeah, I think that's definitely a step to happen. I'm not sure we're really, I think we're still in the kind of stage of like everyone creating their own law. Just like in the U.S., there's been talks of, oh, well, we don't want 50 different state laws. But it looks like that's where we're going.
Yes.
And I think the same thing in the world is kind of that's where we're going. And maybe when there is a law everywhere, there'll be more harmonization. But it's sort of it's not clear like where that's going to happen. Like where the body that would harmonize would exist and how that would actually take place. And then I guess could this create a set of have and have not companies, the companies that are big, that can afford to localize their data. So the Googles of the, it's ironic that the EU, I think a lot of the GDPR and a lot of the EU privacy regulation was created because of, big, gigantic US tech companies and the problems they create. But yet they're the ones who can localize. They're the ones who are able to adapt to this environment, but everybody else can't. And so we'll just start to create some companies that, they're the ones who can localize everywhere. And then there'll be companies that can't, and that will be the world. Then only the big will, these laws start favoring the big, gigantic companies.
Yeah, it's cost prohibitive for, small and medium businesses who are still trying to operate in that space, and even some larger businesses. And I think they're going to be faced with making some very difficult challenges as to whether, the cost benefit analysis is there for them to continue operations in those specific jurisdictions, or, with all the regulations and compliance fees and potential enforcement actions that they would face for not being able to be compliant, and balancing that with, what their revenue is that they're generating out of those individual jurisdictions. And I agree. I think eventually there is going to be a point where the governments will inevitably realize, maybe we've gone too far in some of this that are a bit more restrictive, that have not allowed us to be able to attract companies into our countries to operate because of these potential restrictions. And then, additionally, not just having the laws in place, but some of the cross-border data transfer proposed restrictions, such as in China and India, actually require like government authorization to be able to actually let the transfer go forward, or additional levels of security assessments that have to happen. And to be able to do that, to your point about, doing that for every single transaction that happens, just is not practical in an operational capacity. And so it just begs to question what the future is going to look like in trying to operate in these different spaces, and how companies are going to have to prioritize compliance with these specific data security laws over making some difficult choices about their other business operations and how they're going to fund those.
I was going to just pitch in there because people outside of Europe might have the misconception that Europe is itself aligned, and I'm speaking to you from Ireland, where we seem to be sort of the whipping boy of the European Union in terms of trying to apply some sort of pragmatic application of GDPR principles to the very big tech companies that you just mentioned, Dan. And there isn't a really proper intellectual engagement on this. This is a case of hang them high and find them big, and if you find them big, you should have find them bigger. There's no philosophy that seems to be driving a lot of this stuff, other than, as Gabriela very eloquently pointed out, the ECJ's starting proposition of all these cases is that they're a guardian of a fundamental right, and therefore when they get their hands on these cases, they jump off from there as their starting point. And that's fine when you're thinking about the very real issues that are going on in Ukraine and so forth, and you're looking at privacy violations and how they could become so important. And in fact, much of privacy law was indeed sparked off by things that happened in World War II. So it's fine when you apply it at that very lofty level, but when you try and apply it to ad tech, right, or when you try to apply it to like cookies, honestly, our fundamental human rights are being infringed by. I feel more infringed by all of these cookie banners that I have to swipe out of the way than I do by anything that might be going on behind the cookie walls themselves. So I find it very challenging. I think the DPC in Ireland finds it very challenging to try and come up with precedential decisions that that allow businesses to plan and operationalize themselves in a way that's responsive to the requirements of GDPR. And what we tend to get back from the other EDPB members, particularly having lost the UK, which was the only other common law English-speaking jurisdiction in the EU, is something that I find very hard. I find it very hard to put any sort of theme or consistency around it.
Yeah, one thing that I'll preface my comments by saying I really like the GDPR. I think its goals are great. I think it does more than the vast majority of other privacy laws. But I also think that there's a lot of what I see is form over substance. A lot of steps that seem more about, doing things that look good, creating paper and documents and, the cookie notices that really elevate form over substance. It's not clear that privacy is improved by these things, and that these things are actually meaningful. And I guess the latest decisions on Google Analytics, for all the problems, there are problems with privacy there. But I guess the thing I wonder is, can you have the internet in the EU? Because anytime somebody visits a website from the US, from within the EU, there's a collection of data. And I am struggling to see how that's different, and how that the principles of these decisions don't apply to visiting any website or any kind of logging of information from a site, because it'll log an IP address, which is personal data. So can you have the internet in, any kind of US internet sites in the EU under these decisions? Am I missing something? Because I look at that and I say, I don't get it. Like, I don't know how this is supposed to work.
Honestly, if you read some of the decisions, you'd think that nearly that was the goal, to shut down the internet. And in fact, I have a different hunch about where this might go. I think the GDPR is referred to by the DPC sometimes as the law of everything, and that it's getting the blame for all of the harms on the internet. at the moment. So everything has been hinged against a privacy harm. And some of the laws I mentioned at the outset that are coming down the track are going to be more specific to maybe sort of tangible harms that people might be really more concerned about when they think about the GDPR. So I'm thinking about content moderation, online safety, kids' data, child sexual material, sexual abuse material, CSAM stuff. They're real harms that people really, I think, are aligned around, and like, we need to stop them, we need to address them, we need to do better on the political interference and so forth. At the moment, it seems like the GDPR gets the blame for all of those harms and not addressing all of those harms. And I wonder, as these other laws come in and start picking apart and introducing standards in relation to harms that aren't just privacy specific, will these jump off the deep end privacy cases start becoming a little bit more rational?
Yeah, because in a way, I feel like the GDPR, interestingly, it's sort of too much and too little at the same time. There are a lot of problems that are unaddressed, but wow, has the cookie been smashed? I mean, we've smashed the hell out of cookies, and we've really knocked cookies out of the park. But what about these other big problems that I think are real problems that need to be addressed? And I think maybe it's just easy to go after cookies, just an easy target, but I think it's unfortunate that so much attention is on things that matter a lot less when there are real serious problems out there. And I hope that we see the law really go after some of these tougher problems, which I think have a lot more important implications. Gabriela?
I want to chip in there a bit, because I've been working for 8 months or so together with my colleague Sebastião Barros Vale, our FPF fellow in Brussels, on a comprehensive case law report on automated decision making and profiling, and how the GDPR has been applied to specific ADM. So ADM stands for automated decision making systems in very specific cases that can actually create a lot of harm. So I just want to give the perspective that only because we're not hearing in the US about these other cases, or we're not looking at them too much, because most of them are frankly European in context, it doesn't mean that the GDPR is not there. So we're hearing about Google Analytics and cookies because all of this has to do with transfers, and this is where it really hurts, right? The US and companies here right now. But we've looked at cases where there are automated decisions about distributing social welfare, social benefits, where the GDPR intervened. Cases where the shared economy workers, right, like food delivery workers, were subject to unfair algorithms, like in the Fudinio case in Italy, and that actually obtained some protections thanks to the GDPR, because the GDPR applied to that situation, and perhaps not labor law in some of these cases. So I want to offer that perspective as well, as we're talking about the GDPR and how it cares only about cookies and things like that. There's much more to it than the cookies, but because it was built in such a way, it does vacuum everything that's personal data, including a cookie ID, which is considered a personal data, exactly because it was built to vacuum anything that can be linkable to an individual.
Yeah, I think that's really helpful, and that we only have a few more minutes left, and I'm curious what you see, any other things on the horizon, what you see about the future direction of enforcement. I mean, we really are seeing a kind of, I think, a really heavy wave of enforcement in the EU, which it is nice to finally see the GDPR really start to come into enforcement, which was slow for the first few years. Any other trends that you see developing Final thoughts.
I think one interesting one is 4 years ago, we probably thought that class actions and civil claims would be a big thing under GDPR, but they're not getting much traction at all, really. So there's many opportunist claims have been brought, but they're not, they don't seem to be. The courts seem to be seeing them for what they are in terms of, an opportunity to try and make a buck out of an insignificant privacy infringement. They don't seem to want to go there in Europe. So perhaps expressly trying to avoid the type of class action suits that have developed in the US over the decades. So that would perhaps be one of the fears that we would have had some years ago that doesn't seem to have crystallized in Europe.
Anyone else have any other thoughts?
Yeah, I'd add to that too. I think as we're seeing these complementary laws kind of come down that Rob mentioned, and NIS2, for example, and we're seeing the level of potential penalties and compliance regimes and really higher level of scrutiny that is being placed in the law. I think we're going to see additional enforcement actions that are coming in a wide variety of areas. So you could potentially have a data security breach that has GDPR related implications for the privacy side of it, as well as security related implications from these newer laws, around this too. And I think companies may be looking at enforcement actions coming in on multiple fronts. And so that is something that we're seeing. It's same kind of similar situation in China. One incident could lead to enforcement actions under multiple laws that are very closely related. And so I think we're going to see that going forward in the future as well.
Yeah, very interesting. I have a lot to say on the private right of action that Rob talked about. I'm a little bit more of a fan of it, although I think there are some issues with it. I do think it can be good for enforcement. It could be a good topic for another webinar one day, is the pros and cons of it, because it's become a big controversial issue in the U.S. and a big sticking point in some privacy laws in the United States. But I think that it didn't used to be as controversial. It used to be a part of privacy laws, and it wasn't as big of a deal as it is now. But thank you all for joining me today. I wish we had another hour to keep going. I think there's so much more to talk about, and hopefully we can talk more about some of these issues in the future. I'm sure they're not going away, and there'll be more countries, each with their own adequacy decisions. So it's not just the EU, but it's going to be everywhere around the world has their own adequacy now, and it's all going to diverge, plus all the new laws and new developments. So a lot to talk about, and thank you, everyone.
Thank you, Dan.
Thank you so much.
Thank you, Gabriela. Thank you, everyone.
Thank you.
Thank you.